Chief Justice, they may be waiting for you to tell them that they can be seated.
You may be seated.
Good evening. My name is Rachel Flynn, and on behalf of this year's Moot Court Executive Board, it's a great privilege to welcome you all to the 29th Annual John W. Davis Appellate Advocacy Moot Court Competition Finals. Thank you all for being with us this evening. As you see displayed in your program, this evening's competition is named in honor of John W. Davis, and that's whose honor we hold it in each year. Mr. Davis was a 1892 graduate of Washington and Lee University School of the Undergraduate School, and he was a 7-year general. He graduated from the law school in 1895. He was renowned for both his advocacy skills and public service, and was indeed considered the finest Supreme Court attorney of his day. Davis argued before the court, the United States Supreme Court, 139 times before his death in 1955, and at that time that was a 20th century record. Before I have the honor of introducing our very distinguished judges panel this evening, I'd like to just make a few thank yous to a lot of the faculty and professors who have helped us so much with getting this competition started. First of all, thank you to all of the competitors. Thank you to our advisors, Dean Evans, who's unable to be with us tonight, and Dean Danforth. Thank you to the professors who had the daunting task of judging the semifinal round, Professor King, Professor Massey, and Professor Miller, and thank you very much to the professors who judged the briefs, and that was Professor Shaughnessy, Professor Spencer, and Professor Murchison. Thank you all very much. Today we're going to hear some truly outstanding arguments before a very impressive bench. This bench is not only very impressive, they are very modest, and in fact they have insisted that I not give them a lengthy introduction, but we're just going to give them a little bit of an introduction. In any case, with us today we have Judge Glenn Edward Conrad, who's from the Western District of Virginia, United States Federal District Court. We have Judge William Johnson, who's from the District of New Mexico, and we also have Judge Henry Coke Morgan Jr., who is from the Eastern District of Virginia. The Honorable Glenn Edward Conrad is the United States District Judge for the Western District of Virginia. Judge Conrad, in 1971, earned his Bachelor of Arts degree in Government from the College of William & Mary, where he later earned his law degree. After law school, he served as a United States probation officer and a law clerk, and then continued his service with his nomination to the federal bench as a United States Magistrate Judge for the Western District of Virginia. In October 2003, Judge Conrad was appointed as the United States District Judge for the Western District of Virginia, where he continues to preside over federal cases. Now, as I mentioned, these judges have numerous accolades, so I'll try to be brief at their insistence as to membership and leadership in professional organizations. Judge Conrad, very notably, is president of the 10th Dalton American Inn of Court. It's a litigation entities in Roanoke. He's a member of numerous bar associations. He served as Chief Instructional Counsel and Program Director for the Boys State of Virginia, for which he was inducted into the Hall of Fame in 1995. He's a lecturer and panel member in numerous continuing legal education seminars, similar to the one that we had in this courtroom actually minutes ago. He's judged numerous moot court and trial advocacy competitions and continues to preside over the Western District of Virginia Court Security Committee. Next, we have the Honorable William Johnson. Judge Johnson was born and raised in Roanoke, Virginia. He attended college right next door at the Virginia Military Institute and accepted a reserve commission as a lieutenant in the United States Army Reserve thereafter. And at that time, decided that he wanted to spend some more time in Lexington and decided to attend W&L Law for his law school career. He began his practice in private practice at the firm of Bracewell & Patterson in Houston, Texas. He later moved to Roswell, New Mexico, and joined the firm of Heaple, Cox, Eaton, Caulfield, and Hensley, where he practiced in the areas of commercial oil and gas litigation, which then led to bankruptcy litigation, interestingly. In 1995, he became a New Mexico State District Judge for the 5th Judicial District of New Mexico, where he had a general jurisdiction docket of criminal cases, civil cases, domestic relations, and children's court cases. He continues to serve as the 10th Circuit representative to the Space and Facilities Committee, and he enjoys that role. He lives with his wife Loretta in Albuquerque, New Mexico, with their 4 children. And our third and final judge for this evening is Judge Henry Coke Morgan Jr., who will be serving as our Chief Justice. Judge Morgan was born in Norfolk, Virginia, and continues to serve there as a United States District Judge for the Eastern District of Virginia. Judge Morgan is a 7-year general. Judge Morgan earned his Bachelor of Sciences degree from our undergraduate campus, and then he attended WNL Law to earn his Juris Doctorate degree. In 1998, interestingly, Judge Morgan earned an LLM in judicial process from the University of Virginia. While at Washington and Lee, he excelled in moot court as well as law review, and as an upper-level student won second place in the Davis competition. He accepted a reserve commission as a United States Army Reserve Lieutenant. He had a successful private practice and also served as Assistant City Attorney in Norfolk, Virginia. He has been a member of the James Penn American Inn of Court and serves on various bar associations, and also has served on the Judicial Conference for the Committee on Space and Facilities. I should highlight the fact that all of our judges have vast experience actually in judging moot court competitions, and I mentioned that Judge Morgan was one of our winners several years ago in the Davis competition, and that I should also highlight that Judge Johnson was first place during his time in Washington. I believe that was in '83. Is that correct? Okay, and at present, Judge Morgan resides with his wife, Marnie, who's with us this evening, and the two enjoy spending time with their 3 children and 6 grandchildren. So as you can tell, we have a very distinguished panel of judges today. They are incredibly brilliant judges. It's been a great privilege to host them this weekend, and I hope that you will enjoy listening to the bench this evening and listening to some great arguments. Thank you for your careful attention. I'm now going to turn you over to Arif Narani. Crystal Doyle and Arif Narani have served as the 2008 Davis Moot Court Competition Administrators. They've done a fantastic job. This competition has been a great success, and I know that it's been very enjoyable for all the competitors. Crystal Doyle is unable to be with us this evening, but we thank her for her hard work, and Arif will be here to go over the competition a little bit. Thank you for being here.
Thank you, Rachel. Let me first begin by mentioning Crystal, my co-administrator. Unfortunately, Crystal could not be here today, but in all honesty, without Crystal's hard work and dedication to this activity, the Davis competition would certainly not be a success. Crystal poured hours into Davis, and I want to thank her personally. It has been a privilege to work with her, and she's an invaluable asset to have by her side. I also want to thank the Moot Court Board that assisted Crystal and I throughout the competition. The folks sitting to my left not only helped and assisted in judging the preliminary rounds, but dealt almost on a constant basis with the administrative and logistical tasks that usually require immediate attention. We probably wouldn't be here without you guys, and thank you very much. The John W. Davis Moot Court Competition is an appellate advocacy competition held annually here at the law school. Each year, the competition involves a contemporary question of constitutional law. This year, the problem centers on the Fourth Amendment and the warrantless search of an automobile incident to an arrest. Before I speak about the actual problem itself, I want to describe the process of the Davis competition. 69 third and second year law students participated this year, and to my knowledge, it's one of the highest participation rates Washington and Lee has ever had. The competition consists of 2 components: the submission of an appellate brief and the presentation of oral arguments before a panel of judges. Students write the briefs individually or in teams of 2, but all participants argue alone. Competitors advance from the first round based upon their performance on the brief and their oral advocacy skills, but advancement in later rounds is purely based on the oral advocacy component. From those 69 students who signed up, only 16 advanced to the quarterfinals, and only 8 made it through to the semifinals. Narrowing down the pool was truly one of the hardest things I've ever had to do. The oral arguments in the preliminary rounds were truly outstanding. Everyone did such a great job responding to an often hostile and hot bench, and it certainly made it very difficult to decide who would move on. To all of those that participated, thank you for your hard work and dedication to this activity. It was an honor to serve as your administrator. Only 4 students remain in tonight's final round, which will be conducted by the distinguished panel sitting behind me. For those of you who are unfamiliar with tonight's case, I'll now discuss a general background of the facts. I'll be short. Mr. Gary Autry drove his car into a residential driveway. After stepping out of his vehicle, Mr. Autry was arrested by law enforcement for violating the Deadbeat Parents Act. The arrest itself is not at issue, as the police had obtained a lawful warrant to execute the arrest. Mr. Autry, after then being lawfully arrested, was handcuffed and placed inside a locked police cruiser present on the scene. Another law enforcement agent stood outside the car watching Mr. Autry in order to ensure that Mr. Autry would not be able to escape. It was at this time that the arresting agents searched the passenger compartment of Mr. Autry's vehicle. They did so without having a warrant to search. The police found a baggie of cocaine in Mr. Autry's passenger compartment as well as a handgun, and they used it in his prosecution at the district level. Mr. Autry presently argues that the search of his car violates the Fourth Amendment to the United States Constitution, while the government contends that the warrantless search was reasonable as it was incident to a lawful arrest. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." It is now up to these 4 oral advocates to argue whether or not the search here complies with that text. Thank you again for coming tonight, and we wish all of the finalists the best of luck.
We'll take a brief recess.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Court, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
You may be seated. Petitioner ready?
Yes, Your Honor, petitioner's ready.
You may proceed.
Mr. Chief Justice, and may it please the Court, I am Andrew Fidel for the petitioner of the United States, and I respectfully request to reserve 3 minutes at the end for rebuttal. Thank you, Your Honor. We are here today to discuss the proper scope of the search of an automobile incident to lawful arrest in a world where unforeseen risks to destructible evidence and officer safety can lurk behind any corner. This Court must reverse the 12th Circuit's ruling against the United States below for 2 reasons. First, this Court has already decided this issue in the case of New York against Belton. And second, even if this Court is inclined to overrule Belton here today, a position that the United States strongly opposes, the search here in question is nonetheless allowed under the case of Chimmel against California.
Let me ask you a question on Belton. Belton turned on the risk to the officer. Correct?
Right.
So what was the risk to the officers in this case? I mean, Mr. Autry was already handcuffed and sitting in the cruiser, correct?
Yes, Your Honor. Belton, the exigencies, the Court in Belton identified the exigencies that we found in Chimmel, and that was a severe risk to officer safety. But the main takeaway point from Belton is that that Court established a bright line rule. And that bright line rule recognizes, as in the case of any bright line rule, that at the fringes, you're going to have situations where the exigencies may not be as apparent as they were in the unique facts of Belton.
So what's the concern that Mr. Autry would get out of the cruiser and go for a gun in his car?
Well, Your Honor,
I mean, and the reason I ask that is, I mean, if he got out of cuffs, it's not like there weren't a group of police officers standing by, so they're not going to just sit there while, if Mr. Autry could get out of his cuffs and go to his car.
Well, right, Your Honor. But the importance of Belton was the bright line rule, and the reason that bright line rule was established was because the situation that faces police officers in the field in a world of complex criminal enterprises where there are threats possible.
I understand that. My question is, what is the officer safety issue in this case with Mr. Autry cuffed in a police cruiser and several police officers standing outside, right outside the car?
Right, Your Honor. Well, the important place, if we were to undertake a Chimel analysis, which the United States believes that this search is allowed under anyway, would be that the search has to be considered from the time of the arrest, not the time of the search itself. We believe that that's where the exigencies have to be found, because...
How would you state the bright line rule? If Belton establishes such a rule, in a sentence, describe that rule for us.
Belton, when an arrest is effective of an occupant or recent occupant of an automobile, the search of the passenger compartment of that automobile is presumptively okay. And it's important to maintain that bright line rule for a few reasons. One of them is that rule protects individual liberties, because it gives a police officer in the field a clear idea of what exactly he's allowed to search and what he's not allowed to search. That officer is allowed to search the passenger compartment of that automobile and nothing more. If this court were to discard Belton, the situation that we would find is that officers could fake a Chimel analysis and try to, say, well, I feel fear for my safety, so let's rip the trunk apart.
So you're telling us that it's not necessary in this case at all to consider the exigencies or the potential for the loss of evidence, that the rule is there, and the rule is there to eliminate the necessity to consider all these factors and weigh them in a particular case.
Exactly, Your Honor. The bright line rule, this case, admittedly, falls at the fringes. And it falls at the fringes. The facts of Belton presented a more severe threat to those officers at that time. But that does not change the fact that the bright line rule is important.
So where would you suggest the rule could be crossed under this factual scenario? Did Mr. Autry have to go back into the house to have his car safe from the search? Did he have to be taken to the police station? At what point did it cross over to the other side of the rule?
Well, Your Honor, Belton requires a contemporaneous requirement. So the search would have to be a contemporaneous instance to the arrest. And the United States does not believe that's truly an issue here. And the reason is because the individual, Autry, was just 8 to 12 steps outside his car at the time. If he had gone back to his house, of course, this court has recognized a greater expectation of privacy in the house. But as we've seen in Wyoming against Hupton and many other cases, there is a smaller expectation of privacy in one's automobile. And I think that colors this exception. And that's why the bright line rule is useful. Now, the facts of this case indicate that there was no threat to the officer's safety looking back on it. But it's important to remember that's on a cold record. And it's impossible for us to put officers in the situation where they're running in with unforeseen dangers behind any corner, trying to say to themselves, could a court, under the circumstances, reasonably think that I feared for my safety or destructible evidence? The bright line rule...
Well, now, when we're talking about destructible evidence, what relationship would any potential evidence have to the charge against the defendant in this case?
Well, Your Honor, Justice Scalia, in his concurrence in the judgment in the case of United States against Thornton, identified that perhaps a search such as the one here could be upheld simply on the grounds that there would be evidence of the crime for which the individual was arrested in the car. But I don't think that this court needs to undertake such an analysis. And the reason is because in this instance, the officers had lawful authority to arrest Mr. Autry. In this case, there had been a warrant, but the Belton rule only applies after the probable cause determination has been made. So once that determination has been made, I think it's unfair and poses an undue risk to officers in the field for them to be forced to consider another balancing test, especially given the threats that can face them. In this case, there was no real threat examining a cold record. But what about an officer on a lonely highway, or an officer that's alone in a neighborhood, which is...
But in terms of what the officers knew with respect to Mr. Autry, is that he had an outstanding arrest warrant for failure to pay child support. He's a deadbeat dad. There wasn't any indication that he was dealing with drugs.
Yes, Your Honor. There's no indication that he was dealing with drugs, but nonetheless, when the officers came and did a knock and talk at the house earlier that day, Mr. Autry came out of that house and greeted the officers. Later that day, 2 individuals were arrested at that house for drug-related charges. What we were dealing with here was a complex criminal enterprise, and officers very reasonably could have feared for their safety under the circumstances. Now again, examining a cold record, that may not be the case here, but officers at the time did not know that. And to send officers into battle in the streets as they stand today, and the situations that face officers so often, is very important for officers to know what they can and cannot do.
So you're saying that they were in danger or they weren't?
I'm saying that, Your Honor,
That the suspect was in the car. There was no evidence that need be seized because there was already probable cause to arrest the suspect. So if we're to revert back to Chimmel, what possible ground could there be to find that Belton applies to this situation at all?
yes, Your Honor, if we were to revert to Chimmel, this search would still be allowed. And the reason it would be allowed is because this search has to be examined from the time of the arrest, not the time of the search. And at the time of the arrest, the exigencies could very well have been present. And I think that logic demands such a reading of the case.
Well, what are the exigencies?
The exigencies, Your Honor, would be that under the circumstances with several individuals arrested for drugs in the house that day, and in a situation where there could be threats coming in from any corner, the exigencies could very well have been present at the time. But this is exactly the reason why the Bright Line Rule preserves individual liberties.
Now, the rule has been stated thusly by one of the justices of this court. When a police officer has made a lawful custodial arrest of the occupant of an automobile, he may, as a contemporaneous incident of that arrest, search the passenger compartment of that automobile. Now, that rule contains no requirement that there be exigent circumstances or any spatial relationship between the defendant and the automobile at the time. Now, are you conceding that there must be a spatial relationship or exigent circumstances present in order to justify a Belton search?
No, Your Honor. The central holding of Belton is that they don't look to the exigencies. Now, the Belton holding stood on the Chimmel exigencies, but those exigencies are not prerequisites for the Belton Rule to apply.
Well, there were, in the Belton case, factually, there was a potential where certain of the people involved could have had access to the compartment. There's no potential for the defendant in this case to have access to the compartment that was searched at the time it was searched. And you're saying we don't test it from that time.
Yes, Your Honor. I'm saying that under the circumstances, the Belton Rule simply applies when there's a lawful custodial arrest of an occupant of an automobile, and that the creation of such a bright line rule means that it doesn't stand on the exigencies. And again, there are certain instances on the fringes where the factual scenario doesn't seem to support it as much. But I think it's important to keep in mind that arrests, by their very nature, secure the defendant. So a situation where an individual who had been arrested poses a threat is extraordinarily rare. And that's why I believe logic demands that we read the cases to mean that the exigencies, if this court were to overrule Belton, must be searched for at the time of the arrest.
So you're defending Belton not as one of the more recent of a long line of cases, but really your defense is based on policy purposes. You say that Belton was decided so as to prevent these in-the-field decisions that police officers were sometimes called upon to make before. But I would suggest that perhaps it's created just as many problems as it addressed, because you say there are fringe circumstances. Actually, this isn't that unusual. Now that the standard policy would be to take the suspect into custody first and put him back into the cruiser. So as a matter of policy, it seems to me that this sort of situation would arise more frequently than the one that Belton was directed to overcome.
Right, Your Honor. Well, I believe that to overrule Belton would throw the baby out with the bathwater. And there are circumstances where, and as this, and it may even be frequent, that the exigencies from Schimmel don't seem that present. But in light of the fact that this court has recognized and I see my time is up.
You may finish your thought.
Your Honor, in light of the lower expectation of privacy in the automobile and the Schimmel exigencies and the value of a bright line rule for officers practicing in the field, the United States respectfully requests that this search uphold the individual liberties and protect officers in the field by reversing the 12th Circuit's ruling. Thank you.
Mr. Chief Justice, may I just ask one question?
Sir?
Would you agree with me that Belton would not allow a search of the trunk?
Yes, Your Honor.
Do you advocate that Belton be modified so that the search would not only be to the passenger compartment, but also extend to the trunk?
No, Your Honor, because as I said earlier, Belton was created out of the exigencies of Schimmel. Those are not prerequisites to it, but it would extend it beyond its breaking point. And that would also, Belton Bright Line Rule, one of its benefits is that it actually protects individual liberties. And it would be hard to justify that if a simple arrest would give officers carte blanche to rip apart an automobile.
But let's assume that the officers were looking for something and it wasn't in the passenger compartment and they wanted to search in the trunk. I mean, it would seem to me on the facts of this case, it wouldn't be probable cause to get a detached magistrate to issue a warrant to search the trunk.
Yes, Your Honor, and I believe the Belton rule as it stands now is workable and useful. And I'd be happy to prepare supplemental material on the matter of the trunk. But as far as the Belton rule, I think one of its core strengths is that it doesn't allow officers to rip through the trunk just when they effect an arrest. Thank you.
All right, is the respondent ready?
Chief Justice, and may it please the Court. My name is Kate Lauenseigel, and I will be representing Respondent Gary Autry in this matter. Respondent requests that this Court uphold the lower court's ruling and find, in accordance with the 12th Circuit Court of Appeals, that the warrantless search of Respondent's vehicle was unreasonable under the Fourth Amendment. Your Honors, this case is about Gary Autry, who, while seated, locked in the back of a patrol car, handcuffed, and supervised by a federal officer, was forced to watch as two other law enforcement officers violated his Fourth Amendment right to be free from warrantless searches.
Would you agree with me that Belton stands for the proposition that when a police officer is made a lawful custodial arrest of an occupant of an automobile, he may, as a contemporaneous incident of that arrest, search the passenger compartment of the car?
Yes, Your Honor.
And then you lose, do you not?
That is incorrect, Your Honor. I respectfully disagree with that. That's not my case.
Please explain.
Thank you, Your Honor. Well, there are three main points to this appeal, and my first point goes towards your question, Your Honor. Belton's holding this court in Wheeler against Belton simply was determining the issue before the court, which was the permissible scope of the search, which was allowed, and not the question before the court today, which is a threshold inquiry as to whether or not that search can even occur once the respondent is secured in the patrol car and no longer is within immediate control of the car. So Belton's ruling does not control respondent's case.
Where in the Belton rule does it state that access to the area to be stated or to be searched is part of the rule?
Yes, Your Honor. It states it in two different places. First, within the holding itself, Belton specifically states that it is limited to the particular and problematic context at issue, and that context was further defining within Schimmel against California what area within immediate control meant in terms of the automobile, because lower courts had vacillated over determining that definition, what was within the passenger compartment of an automobile within the area of immediate control of a suspect. Additionally, it states it in a separate occasion where it says that it is simply determining what is the permissible scope in terms of the circumstances of the case. And the circumstances of this case, as Petitioner has already conceded, is that exigencies existed. They did not even address, this court did not address in Belton, this threshold question as to whether or not the respondent is within immediate control and whether exigencies exist once the person that's suspect in that
Your
case.
opponent has suggested that the reason for Belton in the first place was to eliminate the need for officers to weigh these things in the field when they're making split-second decisions and trying to decide what's safe for themselves and the person they have in custody, and yet you would revert back to a situation in which this analysis would have to be made independently in each and every case.
Yes and no, Your Honor. First, Belton's bright-line rule is fine as a supposed bright-line rule in determining the permissible area of the search. Saying that the entire passenger compartment is within the area within the immediate control of a suspect in an automobile is fine. That is what Belton and this court in Belton did. It did not state anything about whether or not the exigencies no longer need to be in existence. And as Petitioner has conceded, and as the court discussed the circumstances of that case in Belton, is that the exigencies were in existence. In Belton, you had 4 suspects. None of them were restrained in any way, shape, or form. None of them were in the patrol car. None of them were in handcuffs. In fact, they were actually just placed around the vehicle, and were therefore still in immediate control of that vehicle. They at any time could have reverted back to the vehicle.
Well, that's true, but I'm not sure that the court, that was the facts of the case, but it wasn't necessarily stated as part of the rule. And you want us to graft something else onto the rule. Now, the problem is this. You want to apply the same rule to searching an automobile as we have applied to the search of a home. Now, an automobile is not the same as a home. It's a mode of transportation. Now, suppose we apply the rules that you want to apply to the home to, for example, airplane travel. How do you justify the searches that take place on airplane travel in light of the rule that you're citing to us today?
Yes, Your Honor.
How do they fit within your Belton analysis?
Yes, Your Honor. The search incident to arrest rule is not only for the home, but it is also for the arrestee's person and the area within his immediate control. In terms of an airplane search, that is different because there's actually a Supreme Court case, and I can offer your justices a supplemental brief, Your Honor, on exactly what the name of that case is, as it's escaping me at the moment. It does state that when those things like luggage or things like that are away from the traveler on the airplane, that luggage and things of that sort is not within the immediate control of that person, and therefore it wouldn't even come under the search incident to arrest exception. In automobile, while there is a lesser degree of privacy expectation, that does not mean that there is no privacy expectation, Your Honor. As this court stated in Coolidge against New Hampshire, the word automobile is not some talisman in whose presence the Fourth Amendment simply goes by the wayside.
I asked your opponent to define what he saw as on his side of the Belton rule, the bright line rule. How would you describe the subject matter that's protected on your side of this bright line?
Yes, Your Honor. What Respondent is asking is that there be the threshold inquiry that the exigencies within Chimel against California must be met. Once those have been met,
But
then
that eats up the
Belton's...
rule, doesn't it? I mean, if we revert back to Chimel, then there's no need to have Belton. Belton is effectively overruled, if not explicitly.
Your Honor, we respectfully disagree. Belton's bright line rule is solely concerning the permissible area of the search, which is that passenger compartment. That bright line rule can still be upheld in today's ruling because it doesn't apply to Respondent's case. The question here before the court is determining, once those exigencies don't exist, whether or not Respondent was in immediate control of his car.
But
He is not.
at a minimum, does it, for us to rule in your favor, there is some curtailment or some further defining of the Belton? Because what you're basically saying is Belton does not apply if the encounter occurs at some point when the individual is either in the process of exiting the car or out of the car. And would that also call into question our holding in court?
There is a few points to that, Your Honor, so let me try and hit them all. First, it would not be a further curtailment of Belton. This court within Belton stated that the exigencies must be present. It said that its holding, this court said that its holding was based on the circumstances in that case, which was that exigencies were present, which is what we are proffering to the court today.
Well, the exigencies were arguably present in Belton, but they didn't state that as part of the rule.
That is correct, Your Honor, but that is because as part of that rule, they were simply determining the scope of the search. And here we are backtracking to that threshold issue which must be met and which is met under Chimmel.
I think you're asking us to rewrite the rule and add an element to it that there has to be exigent circumstances. Or perhaps it's your argument that cases interpreting Belton have already done that. Are you saying that cases interpreting Belton have assumed that exigent circumstances or a spatial relationship is part of the Belton rule?
Yes, Your Honor, some lower court cases have stated that, and other lower court cases have extended Belton beyond that, stating that exigencies do not need to exist. To address both of your concerns, I feel, in Thornton against the United States, this court did not address this issue before the court. It did not address this threshold inquiry because the lawyer for Thornton conceded the fact that he was in immediate control of the car. So Thornton actually simply further defines Belton ruling and does not address any issues before the court today. It simply defines within terms of Belton's ruling that it can apply to both an occupant and a recent occupant. What Respondent is asking the court to decide today is that Belton's ruling, while it is still a bright line rule and determines only the permissible scope of the search, that part of that rule is that the twin exigencies within Chimmel, one of them must have been met before even applying that rule to cases such as Respondent's. And here that cannot be met. There was no exigent circumstances in this case. Respondent was in the back of the police vehicle, he was handcuffed, and he was supervised. There's no way that you could state that he was still within immediate control of that vehicle. Additionally, Your Honors, in the United States against Robinson, that case is distinguishable from the one before the court today. That concerned simply the arrest of a person, in which it stated that you could not litigate these exigencies.
What did Justice Scalia say about Robinson and Thornton?
Yes, Your Honor. Scalia and Thornton, Justice Scalia, his agreement with the Thornton decision did not turn on the actual opinion of the plurality of that court. What he said about Robinson within Thornton was simply that it acknowledged that the exigencies within a person always existed.
Well, did he suggest that it might be better to scrap Belton and adopt Robinson and extend it to an automobile context?
He did, Your Honor, but that was because within his reasoning, the plurality's reasoning, that these exigencies exist or that the scope should be this bright line rule. It was because he felt that in terms of looking for evidence, that within an automobile you should just be allowed to look for the evidence of the crime. And that is what him and Justice Ginsburg both
Perhaps that
argued.
would be a better rule than Belton. I mean, if you want a bright line, that would be as bright as you could possibly get with it. If someone's arrested, officers have a right to, if the person's in custody and there's been some lessening of his Fourth Amendment right, the officers have the authority to search a vehicle that was operated or occupied by that person.
Yes, Your Honor, that would be a better bright line rule. But the problem with that bright line rule
Well, you can see that would be a better bright line rule.
I can see that in terms of the scope of the search, it might be a better bright line rule in terms of the scope of the search.
So you
but
agree
that's
with Justice
still,
Scalia?
no, Your Honor, because that's determining the scope of the search and not the actual incident of the search, that threshold question of whether or not the search should occur. Additionally, this court has constantly eschewed using bright line rules in the Fourth Amendment context, because this court has recognized that the Fourth Amendment context should be determined by the totality of the circumstances, and that reasonableness inquiry is a totality of the circumstances decision. So to adopt an even further bright line rule that limits the privacy interests that individuals have would be against this court's jurisprudence in general in terms of Fourth Amendment doctrine.
Does the record indicate, from a factual standpoint, whether or not your client drove his vehicle up? Does the record establish whether he knew that officers were right there on the scene at his house?
Your Honor, the record is a little shaky in this terms. He knew, I mean, he was driving up to his house and saw the officers.
And that was at his house?
I'm sorry, the house that he was staying at in terms of the other two defendants, Nerani and Doyle. So I'm assuming, and the record is slightly unclear on this, but I'm assuming that as he pulled up, he could see that the officers were there
Right.
at his home.
And the reason I ask that is because I would agree with the notion that the Fourth Amendment protects your client from unreasonable searches and seizures. But the Fourth Amendment doesn't protect him from being a moron. And it strikes me that if the officers are there arresting the other two, Ronnie and the other individual, on drug charges, and your client is driving right into the scene, stirring up a hornet's nest, if you will, that the officers certainly have a reasonable or concern for their own safety with a potential comrade coming on to the scene.
Yes, Your Honor, the record does speak towards that issue. The record was clear that all of the officers thought the scene was safe once they had established control over Respondent and had arrested him, as they were allowed to under the arrest warrant. The problem is, with your analysis, Your Honor, is that just because he was driving to the home where he was staying at, where there may have been illegal activity occurring, does not mean that his Fourth Amendment privacy rights should be thrown away simply because he may have associated with criminals. He might not have known they were criminals. The record is unclear. It does not state whether or not he was a part of this supposed criminal enterprise that the petitioner would have you believe.
Well, I agree with everything you've said, but and certainly I would agree with you that the record does indicate that with respect to Ronnie and the other individual who was arrested, that it had been secure, but then somebody else is coming onto the scene.
Yes, Your Honor.
I mean, would the officers not have a legitimate concern for their safety?
Well, Your Honor, there are two answers to that question. First is that if the officers had had a legitimate concern for their safety, which the record shows that they did not, then that would have been satisfying Chimmel's justifications, which would have given rise to the possibility of Belton's rule applying to my client. That is not the case before the court today. Additionally, within Mincy against Arizona, this court stated that the time of the search incident to arrest exception, it applies at the time. I see my time is up. May I finish?
Yeah, please.
Thank you, Your Honors. That the time of the search, that the exigencies are determined at the time of the search and not the time of the arrest. In Mincy against Arizona, this court ruled that the exigencies were no longer present, and because the exigencies were no longer present, that the warrant requirement came back up. And so here we are simply asking the court that since exigencies were not present and Belton did not apply, that therefore the warrant requirement should be in effect. Thank you, members.
Thank you. I believe the petitioner reserves 3 minutes for rebuttal.
Yes, Your Honor, there's just a few issues I'd like to discuss briefly. Respondent has discussed the case of Mincy against Arizona. I think it's important to keep in mind that in that case it was a murder scene and the search was ongoing over several days. And it was also a search of a home, which is clearly distinguishable from the situation we have here. Respondent also suggests that Justice Scalia's approach in the concurrence in Thornton would be a better bright-line rule. Although the United States has not litigated this below, the United States would still win under this because the respondent, Daniel Autry, was arrested for a deadbeat dad statute. There could have been receipts or checkbooks in the car.
You're here to defend the Belton rule. As the court was constituted 4 years ago, do you think that Belton would stand if the issue had been clearly presented to that court? You've read Thornton. Give me your opinion as to what those various opinions mean.
Your Honor, I believe Belton would stand. And I believe Belton would stand because at the end of the day, its value is simply greater than the risk that's posed by the fringe circumstances that we arguably have here. I would also, Respondent has pointed out that the United States concedes that the exigencies were not present. Again, the United States does not concede, just to be clear, that the exigencies were not present. We believe that the relevant time to look for the exigencies is at the time of arrest. And in that circumstance, as Your Honor had stated, Daniel Autry drove into a hornet's nest. I believe that it was fairly clear that those exigencies very well could have been present at the time of the arrest.
I understand your opposing counsel's argument that you're not Respondent's not asking this court to overrule Belton, but to take it in the context in which it was presented, where there was legitimate concerns for officer safety.
Your Honor, I believe the respondent mistakes the basis of Belton for prerequisites. As Your Honor pointed out, why even have a bright line rule, the Belton rule, if the officers must search for the exigencies in advance anyway? Remember, this rule only applies in circumstances where there has been a probable cause determination or a warrant obtained. So once that threshold question has been reached, why must we add another threshold question, another challenge for officers in the field before they can effect the search incident to the arrest? Thank you, Your Honors.
Thank you. All right, the court will brief the participants and thereafter take a brief recess.
All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Be seated, please. The petitioner ready to proceed?
Yes, Your Honor. Petitioner is ready.
Please do so.
Chief Justice, and may it please the Court. My name is Victoria Porter, and I represent the petitioner of the United States in today's argument. Your Honor, I would like to request 2 minutes for rebuttal before I begin. Your Honors, the issue in today's case is whether the search of the respondent's car was a legal search incident to arrest exception to the Fourth Amendment's warrant requirement, in light of the fact that at the time of the search, the respondent had his hands handcuffed and was seated in the back seat of a police car. Now, the Belton rule applies to the search of the respondent's car and makes it a legal search incident to arrest for 3 reasons. First, the search of the respondent's car was limited in scope and it was made contemporaneous to its lawful custodial arrest. Second, the Belton rule makes a search of an automobile following the lawful custodial arrest of its occupant categorically reasonable. Thirdly, policy reasons support applying a bright line rule over a case-by-case approach in order to provide a workable definition of the scope of the search for police officers in the field and in order for them to protect their safety.
But doesn't Belton, does it not? I mean, it turns on the risk to the officers.
Yes, Your Honor, it does.
So what was the risk to the officers in this case?
Well, Your Honor, in Belton, the court said categorically that the interior compartment of the automobile is the scope over which the arrestee has possession and control at the time of his arrest. And the area over which he has possession and control was decided in Schimel to be the area over which he could potentially grab a weapon, potentially produce evidence and destroy that
Right, and I
evidence.
agree with you. But in this case, Mr. Autry is handcuffed in the back of a police cruiser. So you had officers outside of the police cruiser and you had his car. What was the risk to officer safety?
Well, Your Honor, the Belton rule doesn't necessarily hinge on the actual and present risk to the officer's safety at the time of the search. More likely, it hinges on the presence and the risk of officer safety at the time of the arrest.
I mean, if Mr. Autry somehow got out of his cuffs and bolted from that car, do you think there's police officers standing around and sit there and then go to his car?
No, Your Honor, but we're arguing that the bright line rule approach advocated in Belton will apply to a myriad of fact patterns. And unlike the fact pattern in Belton, when there was a very obvious and imminent threat to the officer's safety while conducting the search, the fact
What about
pattern...
the Mincy case? Doesn't the Mincy case indicate that the officer safety or the exigency portion of the rule, if there is indeed an exigency portion of the rule, applies at the time of the search, not at the time of the arrest?
Correct. And at the time
The problem, again, in analyzing the Mincy in opposed to this case is that in Mincy there was an overly expansive time frame that the search was involved in. In this case, the time of the search was limited to be contemporaneous to the arrest of the individual in question.
Well, and it did go on for a long time, but the point was, at the time where the search was challenged, there was no longer any threat to the safety of the officer. Well, at the time this search was conducted, isn't it true that there was no longer any threat to the safety of the officer?
That is true, Your Honor. However, again, we believe that Mincy is distinguishable because the contemporaneous requirement in the Belton Rule hinges on a closer nexus of both a spatial and a temporal frame from which the arrestee must be to the time of the arrest.
The Court of Appeals applied the Belton test. They did so using a Chumbo analysis, and they ruled that this fell on the opposite side of the Belton bright line from your point, from your perspective. What did the Court of Appeals do wrong? What was in error about the Court of Appeals opinion?
Well, the 12th Circuit relied on a very narrow reading of the Belton Rule. The 12th Circuit held that in order to apply the Belton Rule, the Chimel prongs needed to be in existence prior to the application. We urge the Court that the Belton Rule, while it didn't overrule the Chimel prongs in any way whatsoever, it merely said that there is a different fact pattern involved when the arrestee is an occupant of a car for numerous reasons, one being that a car is a different situation than an arrest that occurs inside a home. Arrest cannot physically occur inside a car. However, once the arrestee is removed from the car, the exigencies present and the dangers lurking inside that car still exist once he's been removed from the car and arrested.
Was the Court of Appeals correct or incorrect in applying a Chumbo analysis to decide which side of the bright line this case falls on?
The Court of Appeals was incorrect. We believe that the Belton Rule inherently from the inside out applies its own exigency analysis.
So Belton operates and stands independent of Chumbo?
It does, Your Honor. We believe that the Belton Rule, while not in conflict with Chimel, does not necessarily rely on the justifications that were present in the Chimel search in order to enact the rule and to uphold that a search is legal.
Do you believe the Belton Court was trying to establish a new rule without reference back to the factors that were considered important in Chumel? Do you really believe that?
It wasn't entirely dividing itself from Chimel, but the Belton holding did rely a lot on the holding in the United States against Robinson, where this court held that the fact of a lawful custodial arrest, inherent in that fact pattern, there are exigencies that exist. And we're going to say that they exist in every lawful custodial arrest. And as a result, in the United States against Robinson, the court held that you may search the person of the arrestee. Similarly, the Belton Rule applies its own analysis of the exigencies present in every
Well, you
arrest
appear to be
situation.
conceding that the Belton Rule does require an exigency element.
Yes, Your Honor. We concede that. And we believe that the Belton Rule from inside out limits its application to the points where those exigencies exist. In Belton, the court was saying inherent in every arrest situation where the arrestee just got out of a vehicle or was in a vehicle when he was arrested, there are going to be significant dangers in that situation. And as a rule, we're going to say that those situations allow the officers to define the scope of that search as the interior compartment of the car and the car itself.
Do you think Belton should be expanded to include the trunk?
No, Your Honor, we're not arguing for that today, and we do not believe it should be expanded.
So you would agree that if the officers wanted to search the trunk, they would have to get a warrant?
Yes, Your Honor, we would agree with that. Despite the court's holding in Michigan against Long, in which the court upheld a Terry analysis as applied to the search of a car, we believe that the Belton Rule would not extend to the trunk area of the car.
Why couldn't the officers have gotten a warrant here? There was no one in the car. They had enough people present to secure the scene. Why couldn't they simply have gone and made an application and had a magistrate issue a warrant for the interior of the vehicle?
Well, Your Honor, it's unclear whether the officers believed they had probable cause on the scene to search the car.
So now they can search without probable cause as long as someone is arrested within 8 or 10 feet of the vehicle.
Well, with the Belton Rule, what we're saying is that the government's interest outweighs that individual's privacy interests, and the exigencies of that arrest situation should allow officers to limit the dangers lurking in the car, should act in their own safety to prevent
the destruction of evidence, to prevent dangerous things from existing inside the car, and perhaps turning on them while they conduct their searches.
But those very dangers that you're talking about could be present in the trunk. And so I'm having trouble seeing that if they cannot, if there's not probable cause for the issuance of a warrant for the search of the trunk, or in response to my colleague's question, there's not probable cause to go get a warrant to search the interior of the car. I mean, what's the basis then for allowing, it seems like a trampling on the Fourth Amendment then? So even though there's not probable cause, have at it, go search the interior of the car, even when the defendant's sitting in the back of the police cruiser.
Well, Your Honor, the Belton Rule limits the scope of the search to the area over which the arrestee had possession and control at the time or immediately prior to his arrest. And the Belton Rule defined that area only as the interior of the car. And in doing so, the Belton Rule limited the scope of its search in order to provide a safety for that individual and for that individual's privacy interests in his trunk. Your Honor, we believe that the policy reasons supporting a bright line rule application would do two things in this case. First, it prevents police abuse of discretion in the field. Secondly, it protects officer safety. Now, a bright line rule approach is more apt than a case-by-case analysis in these sorts of situations where arrests of recent occupants of cars are conducted for several reasons. Between 1997 and 2007 alone, 1/5 of all officers feloniously killed in the line of duty were killed while conducting custodial arrests. It's a dangerous situation, and if officers can walk into that situation knowing where they can search, where they can't search, and what are their limits, their safety can be enabled.
Wouldn't we be better off having a rule that permitted the officers to make a search and engage in self-protection in circumstances where the suspect was not under arrest? Would that be a better place to draw the bright line?
Well, no, Your Honor. And going back to the court's holding in the United States against Robinson, that the exigencies present in that arrest situation in part justify the application of the Belton Rule in order and also justify the officers acting to preserve their safety.
Well, Justice Scalia would have us adopt Robinson and apply it more broadly to include automobile searches, but he was critical in the same paragraph of the Belton Rule. So wouldn't Robinson be a better approach? Shouldn't we just scrap Belton and extend Robinson? Wouldn't that make it a lot easier as a policy matter for folks to understand what the law is?
Well, Your Honor, if we do adopt Scalia's approach, as I believe you're referring to in the United States against Thornton, where he wanted to have some sort of a justification more so in place, you lean towards a case-by-case approach. And in doing so, a case-by-case approach undermines the very fact of having a bright line of Belton
He
Rule
says
together.
anytime you make an arrest, if it's adjacent to a vehicle, you can search the vehicle.
Well, Your Honor, the Belton Rule...
Case by case about that.
Well, Your Honor, in the Belton Rule, the case-by-case approach is
I'm
specifically...
talking about Robinson. If you extended Robinson, what would be case by case about that? It would seem to be pretty clear.
Well, if you did extend Robinson to situations, you would also have the problem of where do you draw the line. And this is the positives about the Belton Rule, is that the line is clearly drawn for police officers. If we did extend the rule and perhaps mitigate Belton in the way that Scalia wanted to, we have a problem of, do you draw the line at 8 feet from the arrestee's location? Do you draw the line at 10 feet from the arrestee's location? And if you do, will that require the officer to make an analysis in the field and perhaps put an undue burden on his judgment?
That would be easier than weighing exigent circumstances each and every time an arrest is present.
That would indeed, and that is exactly what the Belton Rule eschews, in the very weighing of exigent circumstances every time an arrest is conducted. And for that reason, the Belton Rule is a positive thing and will give officers a bright line and a way to approach each arrest situation and know where and when they can search.
But there's still some line that has to be drawn. I mean, if your client had been arrested, or I'm sorry, if the respondent had been arrested and taken to the police station, the police can't go then search the car or go bring the car down to the station and search it. So I mean, there's a line that, that's clearly on the other side of the line.
Correct, Your Honor. And we believe the Belton Rule in its contemporaneous requirement does in fact draw that line easily. The court has said that a search is contemporaneous if it's not remote in time nor place from the arrest. Now, this has both a temporal and a spatial delimit. The arrestee must be at the place of the arrest, and the car must still be at the place of the arrest. The Belton rule makes this clear, that that applied in Belton and is an easily applied and workable definition. Therefore, from the Belton rule itself and the contemporaneous requirement in the Belton rule, there's an easily seen line that officers may adjudge and decide where they can and cannot search. Your Honor, I see that my time is over. May I make a brief conclusion statement?
All right, you may make a brief statement.
Your Honor, we believe that the Belton rule should be affirmed and clarified by today's ruling, that the 12th Circuit should be overturned. The search of the respondent's car was a legal search incident to arrest. Thank you.
Thank you. Is the respondent ready to proceed?
Yes, Your Honor, the respondent is ready.
Please proceed.
Thank you, Mr. Chief Justice. May it please the Court. My name is Andrew Finicum, and I represent Mr. Gary Autry, the respondent in this matter. Your Honors, in this case, Mr. Autry, a United States citizen, was arrested out of reach of his vehicle 8 to 12 feet away. He was then handcuffed, placed in the back of a locked patrol car.
Does it make a difference that he's a United States citizen?
Your Honor, it's the Fourth Amendment is about protecting the rights of United States citizens against an overzealous executive that's engaged in the often competitive interest of crime control.
But if he was here illegally or as a legal resident, would he still have Fourth Amendment rights?
Your Honor, he still would have rights against the government. But in this case, he was already under guard in a locked patrol car, handcuffed, and he posed no danger to the preservation of evidence or to the officers in the field. There are 3 reasons why the respondent asked this Court to affirm the 12th Circuit's decision that this search was unconstitutional. First, exceptions to the warrant requirement must be narrowly drawn to fit the exigencies that justify the search. Second, this case is distinguishable from Belton because in this case, the arrestee was not a recent occupant of the automobile when he was arrested or when the search began. Third, because the agents in this case had time to pre-plan the arrest, they also had time to get a warrant, which distinguishes this case from Belton. First, Your Honors.
Your opponent suggests in that latter vein that there was no probable cause for a warrant. Do you disagree?
Your Honor, I do not believe that there was probable cause for a warrant to search the automobile to obtain the things that they obtained inside
So that's
the
a
vehicle.
non-factor. The fact that they could have secured the scene and gone for a warrant is not important in this case.
Your Honor, it is a factor because it's even more important. The reason for the warrant requirement is that when there's not probable cause, a neutral magistrate can say, don't search the vehicle. The point of the Fourth Amendment is not to fix an unconstitutional search after the fact, but to prevent it from happening at all. So if the agents did not have probable cause to search, then they did not have probable cause to get a warrant, and the search never should have happened.
I didn't understand Belton to require probable cause in the most obvious circumstance where someone is arrested immediately outside their vehicle. You don't have to believe that a weapon or drugs are present in order to make that sweep, do you?
Your Honor, the Belton court said that they were not changing the Chimel analysis, but that they were deciding that the passenger compartment of an automobile was inherently within the reach of an occupant of the automobile when he was arrested.
When did this exigent circumstances or spatial relationship become part of the Belton rule?
Your Honor, in Belton, the facts itself, the arrestees actually outnumbered the agent 4-1. They were within reach of the automobile, and they were actually occupants of the automobile when the arrest began. This court in the United States against Thornton addressed a situation where the arrestee was standing next to the automobile, and 5 justices of this court in Thornton refused to extend the Belton rule as an automatic bright line, even in that situation, although 3 of those justices did agree in the judgment that the search was constitutional.
Let me follow up on the Chief Justice's question. I mean, would you agree that Bolton stands for the proposition that when a police officer has made a lawful custodial arrest of an occupant of an automobile, he may, as a contemporaneous incident of that arrest, search the passenger compartment of the car?
Yes, Your Honor.
Don't you lose?
No,
That's
Your
what
Honor.
happened here.
No, Your Honor, because first of all, as the Chief Justice noted earlier, the exigencies must be determined at the time of the search and not at the time of the arrest. And because of when the search happened in this case, the Belton rule does not extend that far. as the Chief Justice cited, Mincy, if there was ever a case where the exigent circumstances of the arrest should continue all the way through the search, it was Mincy, an officer had been killed, there had been gunfire on the scene, and yet this court said you've got to look at the time of the search and not the time of the arrest.
Does the record in this case, from a factual standpoint, indicate whether or not your client knew that there were officers on the scene when he drove his vehicle?
Your Honor, the record...
In parking space.
Your Honor, the record does not say whether he knew that they were there then. But the record does make clear that he knew that the agents were returning. The agents had come, they had talked to Mr. Autry, asked him questions about other individuals. Then they left the scene and did a background check on Mr. Autry and found out that there's a warrant out for his arrest for failing to pay child support. So they returned to the scene with that warrant intending to arrest him.
So they were on the scene when your client drove up?
That's correct, Your Honor.
All right. The Fourth Amendment obviously protects your client against unreasonable searches and seizures, but it doesn't necessarily protect your client from himself from making stupid decisions. So if the officers were there and they had arrested two individuals on drug charges and your client's Johnny on the spot driving up, I mean, aren't the officers acting reasonably when they in terms of the actions that they took? Weren't they reasonable in believing that perhaps your client was involved in the drug trafficking activity that the other two were arrested for?
No, Your Honor. The original arrest is not an issue in this case, and the agents did have reason to arrest my client. However, they did not have reasons to search the automobile without getting a warrant, and it was only after that search that the agents were able to connect him with the narcotics activity that was going on at the scene. Furthermore, while the petitioner argues for a bright-line rule, 16 years after Belton, 8 justices of this court, 7 writing the majority and 1 writing in concurrence, said in Ohio against Robinette that when determining the reasonableness of a warrantless search as an issue, this court should specifically shun bright-line rules and look at a totality of the circumstances on a case-by-case basis.
Well, then you're saying that we should overrule Belton.
No, Your Honor, we're saying that Belton was limited to a specific situation where an officer already has the criminal exigencies. When the exigencies are there, Belton said, presume that they can search the entire passenger compartment.
But the idea of the totality of the circumstances, a fact-by-fact, case-by-case basis is directly contrary to the notion of a bright-line rule.
Not if this court sees that the bright-line rule was that the passenger compartment was within reach of an occupant of an automobile. That was the bright line and the particular and problematic circumstances of automobile searches that this court made. This court said in Belton it was not changing the Chimmel analysis. And in Chimmel, this court said that if this court does not require a showing of exigencies in each case, the Fourth Amendment protections of the individuals in this country will quickly evaporate.
Didn't we essentially say in Belton that by definition the exigencies are present in these automobile situations?
In the situation that was that case in Belton, yes, Your Honor, where...
We didn't confine the holding in Belton to the facts of that case when we announced the rule.
No,
You're telling us that the rule is limited by the facts of that case, but the rule was not so stated in the case, was it?
In the case itself, the court did not make clear how far the Belton bright line rule was going to go. It did say that the rule applied to occupants of automobiles. And this court in Thornton, 5 justices of this court, would not extend that to recent occupants. 4 justices did. And the justices that agreed with the judgment made enough to make a majority. But this court has not extended the Belton bright line rule to a person in the position of the arrestee who was already 8 to 12 feet away from the vehicle when he was arrested and then was locked in the back of the patrol car. And as Your Honor noted, the exigencies of a search must be determined at the time of the search, not at the time of the arrest. The arrest does not make, as Justice O'Connor noted in Thornton, some kind of entitlement on the behalf of the police to search an automobile.
Is there a reasonable expectation of privacy in an automobile that is parked in somebody else's driveway?
Yes, Your Honor. The automobile determination of expectation of privacy was dealt with in Coolidge against New Hampshire, where this court said that the existence of an automobile is not some talisman upon which the Fourth Amendment protections disappear. Furthermore, this court...
Well, let me articulate it a little better. If the expectations of privacy regarding the automobile are they lessened because the vehicle was in, your client's vehicle was in somebody else's driveway as opposed to being, say, in the driveway of his own home?
They were not lessened, Your Honor, in comparison to the government. This court has noted that in situations like apartments, where the person does not actually own the room, there may be a decreased expectation of privacy that the maid or the owner of the establishment might come in the apartment. But there's not a decreased expectation that the government would seize that situation and infringe themselves and search the vehicle. So the expectation compared to the government was not lessened.
Well, let's face it, I mean, the car was in the driveway of somebody else's home. Two people had already been arrested out of that home. So that vehicle could have sat there indefinitely with its owner arrested on another charge. Two other occupants arrested. And how long is he going to sit there? Didn't that give the police the right to make an inventory search of that vehicle?
No, Your Honor. This court has held previously that inventory searches do not give the government an automatic right to search the interior of a vehicle. And this court said in Michigan against Long, when searching an automobile, an agent has to be able to give reasonable and articulable facts for why they needed to not get a warrant first.
And if they're impounding the vehicle, if they're taking custody of the vehicle, I mean, isn't it pretty much standard operating procedure that an inventory search is going to be done?
Well, Your Honor, there's no evidence in the record that they did impound the vehicle. And furthermore...
Well, I mean, I agree with you, but hypothetically speaking, if they, I mean, let's say this, that there's an ordinance, a local ordinance that prohibits vehicles from being unused and not operated sitting out in front of a residence. So if your client is in jail, the vehicle is sitting at someone's house besides his, it's violating the city ordinance, the police are called, they're going to tow it, and they could conduct an inventory search at the time they tow it.
Under those facts, yes, Your Honor, the police could have done a search, but in this case, those facts did not exist. And if the agents wanted to seize the vehicle, if they wanted to search the vehicle, they had time between when they first met Mr. Autry and after they found out that he was suspected for committing a crime to go to a magistrate and get a warrant.
Now, what was the probable cause for such a search? What would you tell the magistrate? Why would you think there would be contraband in the car?
They didn't even know there was a car at that point.
Your Honor, they could have gotten a warrant to search Mr. Autry's effects because of the type of crime he was accused of committing. There was an interstate commerce element to that crime.
They've already found probable cause to arrest him. But are you talking about the discovery of evidence that might be used in a sentencing hearing, a guidelines hearing? What would they expect to find?
Your Honor, the respondent is not in a position to guess what the government expected to find in searching the
I'm
automobile.
asking what you would have told the magistrate. You suggested this is a viable alternative. What would you have told the magistrate as the basis for finding a probable cause?
Your Honor, at the time after the arrest had happened, they could have called the magistrate and explained whatever their concerns were, that they wanted to search the vehicle. But more importantly, Your Honor,
sure, if they want to search the vehicle, but they still have to establish probable cause under the Constitution.
But, Your Honor, respectfully, if they can't establish probable cause to a magistrate, that's why they have to call a magistrate. Because the purpose of the Fourth Amendment is to keep the search from happening if there's not probable cause. The non-existence of probable cause is not a reason to do a search without a warrant. And it is that specific overzealous executive activity that the Fourth Amendment protects. That's the reason that Cass against the United States said that searches done without the prior approval of a neutral magistrate are per se unreasonable.
What if there had been a fourth person in the house? What would that do to your analysis?
Your Honor, it would depend on whether the fourth person had already been secured.
If the person had not been secured, there was a person wandering in the house after the first two had been arrested.
If the scene was not secure, Your Honor, the exigencies very well may have existed. But the agents below testified that the scene was secure. And therefore, if we look at the time of the search, as Mincy requires, the exigencies required for a search incident to arrest did not exist.
So it's still a very broad gray area in your view. that agents have to make this determination, that determination, all of these decisions, and the policy grounds that your opponent cites for the decision development are just kind of wiped away.
Your Honor, the agents of the government are required to make those kinds of decisions in Fourth Amendment jurisprudence all the time. They're required to figure out whether they have probable cause to arrest, whether they have a reasonable suspicion to perform a Terry search. And it would not be an increased burden to place upon them the determination that Chim will require that exigencies exist before a search incident to arrest. Your Honors, when this Court is called upon to protect the Fourth Amendment rights of the people of the United States, time and space matter, even in increments of feet and minutes. And because searches must be narrowly drawn, because the arrestee was not a recent occupant, and because the agents had time to get a warrant while they were pre-planning the arrest, we ask this Court to affirm the 12th Circuit Court's decision that the search in this case was unconstitutional. Thank you.
All right, I believe the petitioner reserves 2 minutes for rebuttal.
Yes, Your Honor. Chief Justice, and may it please the Court, why should the Belton Rule apply to the search of the respondent's car? First of all, the Belton Rule is reasonable. It is reasonable because it's limited in scope, and it's limited to a contemporaneous requirement that judges where the arrestee was in relationship to the place searched, the automobile. Secondly, the Belton Rule is reasonable because inherently in the rule itself, it balances the individual's reduced expectation of privacy in their automobile following an arrest, and balances that expectation of privacy, which is greatly reduced, against the government's interest in protecting their safety and in having a workable rule in the field. Thirdly, the Belton Rule is reasonable because the arrest of the recent occupant of the motor vehicle justifies the search.
I understand the respondent's position, really, that Belton remains intact. The rule in favor of the respondent is simply that we're taking Belton in the context in which it was presented at the time it was decided when there was legitimate concern for officers.
Your Honor, if we begin to judge when the Belton Rule should be applied based on a fact-by-fact, case-by-case analysis, we undermine the entire point of having a bright-line rule altogether. The Belton Rule was put in place so that in different fact scenarios, in different fact patterns, when different amounts of police officers are present at the scene, the rule will still kick in and it will still apply, and it still is based on the same policy justifications for protecting officer safety and preventing police abuse of discretion. In mitigating the Belton Rule in any way, in requiring any sort of ad hoc, fact-by-fact, case-by-case approach, we will be placing an undue burden on the officers in the field, and we will be overturning the Belton Rule altogether. Your Honor, we urge the Court to, affirm the Belton Rule, to clarify it once again, and to overturn the 12th Circuit. Thank you.
All right, the Court will treat the participants and thereafter take you may be seated. Well, we were invited to make constructive comments before we announced our decision. And I'll ask Judge Johnson if he would begin with his comments.
First, I want to thank the Moot Court Board in Washington and Lee for, I guess I came before this. That was the most expensive since my airfare from Albuquerque. But it's great to be back here. This is a very difficult task. With technology now, I sometimes wonder maybe despair the judges from making such a hard decision. You ought to adopt a format like Dancing with the Stars, where the judges, we only get 50%, and then everybody else in the audience gets to vote, and then you tally the scores out. But no, the quality of oral advocacy was superb. In my court, sometimes I get the sense that oral advocacy, oral argument, I don't know if dying art's the right word, but there are more and more motions that are submitted, and they're submitted only on the briefs, and parties don't request oral argument. And I know I will set oral argument if the parties request it, and oftentimes when I look at the file, it's not requested. And I think, to me, there's something to be said about oral advocacy. Obviously, advocacy consists of not only oral communications but written communications. But oftentimes, powerful oral argument can focus a judge on maybe an issue or an aspect of your case that you haven't thought of. So, I guess I personally would like to see more oral advocacy. So, for not only the finalists, but those of you who will soon be practicing law, don't hesitate or don't be ashamed or to go to court and make an oral argument. I think that's part of the tools of the trade of a lawyer, is not only written communication, but oral communication as well. In terms of, I thought all four of you had a command of the law and the facts. In terms of, all of you, if we had said nothing, I'm confident all four of you would have been able to, hit the ground running and go for 15 minutes. But that rarely happens. And so all of you were able to start, you had your text or the points you wanted to make, but then you also answered the questions and were taken in the direction that we wanted to take you in. You also engaged us. It was good eye contact, good use of hands. You weren't looking down, you were looking at us. It was a conversation that you were engaging us in. I was very, very impressed. Also, there were a couple of whom we would say pressing you on certain issues. Don't be, if you can make a concession on a particular point without conceding, the entire argument. And I think on both rebuttals, one of the things I noticed is that when the rebuttal arguments were made, the attorneys kind of picked up on some of the comments that we had made to rebut the other side. But anyway, very job well done.
Judge Johnson's a little modest. Even though he's been here for a week, it's not costing the Moot Court Board that much. He's staying at home. He's from Roanoke and very happy to clean Virginia. I would join in all the things, echo all the things that Chip has said. I thought all of the participants did an excellent job. I think the problem argued very well, and those who are responsible for the problem and the preparation of materials can be commended for a job well done. I would agree that all four of the advocates did an excellent job in moving from the questioning to their prepared remarks, what they intended to say, the points they felt that they had to make. I thought that several of you did better with that than others. But I think all four of you did exceptionally well in that very important area of appellate advocacy. I thought that one of the concerns, if there were any concerns, was that on several points, I think it was pretty clear from the question of the judges that there were certain arguments that we didn't especially like. And I noticed that one or two of you nevertheless incorporated those arguments in your final summation. And perhaps it was because you intended to say what you said and you couldn't change paddles in the middle of the stream, but that's something that you would want to overcome down the road. Stick with what has played well for those who are asking the questions. I, too, share the belief that appellate advocacy is one of the most important qualities for any lawyer to master. It's something that will serve you well if you be a litigator or a trial lawyer or someone who argues regularly before the Supreme Court or the Courts of Appeal. The program here indicates that that very important quality is continuing to develop at Washington and Lee. And I think all those involved are to be commended for a job well done. Congratulations.
Hi.
Judge Moore.
One thing I forgot to say, we did, I know you all weren't allowed to, but we did look at the transcript of the oral argument before the Supreme Court, so to get a little idea of perhaps what some of the justices were asking the attorneys who argued the case recently. And I guess after we take a break and we visit with you, I'd be interested in knowing if some of the questions that we asked, the three of us trial judges, whether the tenor or the approach or the questions, whether they were pretty consistent with the questions you've been asked throughout the competition, or whether we had any kind of different approach that was a little different.
We probably missed about 6 or 7.
Yeah, we probably missed them.
Yeah.
Well, if we missed them, I think the Supreme Court did too. We did review and attempt to incorporate the questions which the Supreme Court justices asked during the oral argument, so we know what concerned them at least. This type of argument is the same type of argument that I frequently hear, and I'm sure that my fellow justices, judges, actually hear. We spend much more time hearing motions now than we do actual trials. Unfortunately, the cost of civil litigation has escalated to a degree that we're not trying nearly as many cases as we used to. But we are hearing many motions. And the type of argument that you present here is the same type of argument that we hear in motions before our court. So it's good practice, not only for appellate advocacy, but for any kind of practice, motion practice, especially before district courts, but also before state trial courts. In district courts, we have the luxury of having law clerks who work very hard to prepare us for hearing motions before we actually hear them. Many state judges have to hear motions without nearly as much preparation, and they have to hear, in most cases, a larger volume of motions. So we have the luxury of having our law clerks help us prepare for these type of hearings. So this is very similar to what we frequently do. Picking up on something that Glenn said, and that is being able to shift gears. The ultimate preparation is being able to shift gears. What I generally do if I'm hearing a motion in real life is I tell the lawyers when they start, I said, these are the issues that concern me. I said, now, you can bring up whatever you want to bring up within the framework of your briefs, but these are the issues that concern me. So they may have prepared their argument to present something on these other issues, but they have to immediately shift gears and focus on what I deem to be the more important. So that's something that you have to learn to do. So being able to field questions and being able to go in the direction in which the questions point you is very important. I'll never forget one case I had where it was not this type of argument, but we had a physician who was just blown out of the water because what the physician had done is changed her record after she had produced them. She actually produced records which said, let's say the light was red, and then after the records were produced in discovery, she went back and changed them and said the light was green. And that came out in court, and then after it came out, the lawyer who was her opponent went through the list of questions that had been prepared to ask this witness, and by the time those questions were finished, the physician had pretty much completely rehabilitated herself. So you have to put aside what you were prepared to say and say what's necessary to respond to the questions that you get from the court. And that only comes from being very well prepared. As part of the introduction, believe it was mentioned by Rachel that Judge Johnson had won this competition when he was here. I didn't win it, I came in second. But when I competed, there weren't nearly as many competitors, I can tell you that. We didn't, because you had 69 competitors. We didn't have 69 people in my whole class. So there was not nearly as much competition, but nonetheless, I was proud then, and I'm still proud, to have come in second in this competition, and I know that Judge Johnson feels the same way about having come in first. But what's important is that you went through this and you got excellent training, and all of you who reached the finals have accomplished quite a bit to have gotten to this point. And I hope that you feel proud of having done so. I can tell you, like I say, I still do, even though I didn't win the ultimate prize, but I was proud of getting as far as I did. So at this point, I'm going to announce the outcome and the opinion of the judges. We thought the runner-up was Andrew Finnegan. And it was our judgment that the winner was Victoria Clarke.
Congratulations to our finalists, to our winners, to our best brief nominees and winners, and let's give a round of applause to our excellent and lively bench. We appreciate them. Have a nice weekend.
Well, before we depart, I really would be delinquent if I didn't thank everyone who participated in the program from our standpoint and arranged all our accommodations. But most of all, I've done quite a number of moot court competitions over the years, and I have never been prepared as well for any competition as I was prepared for this one because of the work of the people who operated this program. They did everything in the world to educate us and to prepare us for this competition. So
That's good.